Welcome and good afternoon, I think, just everyone, to the first of our 3 seminars on employers' liability and public liability topics. Today's session will be given by Tom Lomas and John Wafer. Many of you will know them, but they're 2 very experienced solicitors dealing with this area of law based in our Manchester and Liverpool health litigation teams respectively. I think you should be able to see their brief bios on the right side of your screen as well. There's also my own there. I think, again, for those of you who don't know me, I'm Ian Gardner, a partner in the Manchester Health Litigation team, and I head up our non-clinical claims team. I'm aware that there are varying levels of experience of people attending today, and this first session is intended as an introduction to these types of claims. So any of you who are familiar with these claims and have dealt with them for many years, you may find it more of a reminder of the position. Hopefully though, you'll still pick up some useful tips. There is a lot to cover just because of the breadth of the topics, so I suspect there won't be much more than about 5 to 10 minutes at the end for questions. Though we'll do what we can to answer any burning issues that arise during the presentations themselves. You'll be able to see there's a Q&A option icon at the bottom of your screen. Our contact details will also be visible to you all as well, so you could always email us after the session to deal with any further or in-depth queries. And I think we'll also get a list of any outstanding questions we haven't answered, which includes contact details. So obviously, again, we can follow those up with you if we need to. Everyone attending will receive a follow-up email after this session, which will have a link to the recording and also a sign-up link for the next webinar. So again, you'll be able to register interest for that. The second and third sessions will be much more specific and will cover more difficult areas of law. As I said, today really is an introduction to the topic as a whole. So if we can perhaps just move on to some housekeeping issues. You will have noticed that all of your microphones and cameras have been turned off. That's partly just to help with bandwidth because we're live streaming this. Questions I've dealt with. Any technical issues, a lot of the time it's a question of just trying to refresh your screen or come off the link and go back on. And we find that that does help to re-establish any connection. Feedback is always very welcome. And as I say, we'll do our best. If there are any technical issues during it, if you can pop those in the Q&A, we'll try and get to those. So if I'll now pass to John to begin his section of the talk.
Thank you, Ian, and welcome to everybody, and thank you for joining us today. I'd like to begin by just providing a quick overview of what we want to deal with in this session. So I will start by giving you an overview of the employer's liability and public liability legal framework, and then move on to just the basics really of investigations, sort of documents you're going to need, the evidence you're going to need, and just the things that will give us a chance at least of defending these claims. When I'm finished, I'll pass over to Tom, who's going to run through the issues and processes which arise in dealing with claims in the low value portal, and also some aspects of litigation. Before I actually move on to the legal framework, there are just 2 concepts I wanted to touch on because they are quite important in these claims. And as Ian said, we will deal with these in more detail in the later seminars. So they are vicarious liability and contributory negligence. So what is vicarious liability? Well, in a nutshell, it relates to circumstances in which an employer can be held liable for the negligent acts or omissions of an employee. And you can see from the slide there are 2 aspects to consider with this. The first is whether the relationship between the employer and the employee is capable of giving rise to vicarious liability. To some extent, that's a rhetorical question because it can't, and in the vast majority of cases we deal with, that will apply. A different question is whether there's a sufficiently close connection between the actual act or the omission or the wrongdoing and the employment so that it would be fair and just to hold employees vicariously liable. Now, in the vast majority of cases we will deal with, that will apply, but there will be exceptions under this limb of the test. I won't deal with those today because they will be dealt with in more detail in the seminars to follow. Okay, so contributory negligence. I've set out the statutory provision there on the slide, which you can obviously come back to, but in a nutshell, if you're liable to compensate a claimant, but their own actions or omissions have contributed to the incident and the harm suffered, then there may be scope for reducing the level of compensation you have to pay. And that would usually be by way of either precedent or negotiation. Okay, so the legal framework. These cases are usually pleaded in both negligence and statutory duty. So initially, I'm going to look at the common law or negligence. For the court to make a finding of negligence, a claimant will have to prove a number of things. The first is that the defendant owed the claimant a duty of care. Now, a court will find the duty of care exists if the claimant can show that the damage suffered was reasonably foreseeable, that there was proximity or connection between the claimant and defendant, and that in all the circumstances it would be fair, just and reasonable to impose liability on the defendant. I've mentioned the case of Wilson and Clyde Coal Limited there, just as an indication of the sort of matters which the courts will take into account when they consider what the duty of care is. And in that case, the court took that to mean that the employer should provide competent staff, adequate materials, a proper system of work, including supervision, devising precautions to protect against personal injury, giving instruction and training, and generally maintaining a safe place of work. Having established that the defendant owes the claimant a duty of care, the claimant will then have to prove that there's been a breach of that duty. Now, the standard of care which will be adopted is that of a reasonable person. And what would they do in that profession or that occupation or the activity in question? And then that will be applied to the facts of the case. So once the claimant has established that there was a duty of care and there's been a breach of that duty, they then have to prove that they've suffered a loss, but also that the loss has been caused by the defendant's breach of duty. And in relation to the loss, it must not be too remote from the defendant's negligence. In other words, it has to be reasonably foreseeable or the kind of loss that the defendant would have in contemplation. So if all these criteria are met, there was a duty of care, there's been a breach, there's been a loss, the loss was reasonably foreseeable and the loss was caused by the defendant's negligence, then the claimant is likely to succeed and obtain compensation. And the aim of that compensation would be to put the claimant as far as possible back in the same position that they would have been in but for the defendant's negligence. Okay, so that's the common law. Now, on the slide, I've set out what we call the six-pack regulations, because there are six of them, and you'll see that they relate to different aspects of the workplace. The regulations were derived from EU law, and the EU required member states to implement them into domestic law. So they cover things like manual handling operations, display screen equipment, the provision and use of work equipment, and personal protective equipment. The management regulations are an overarching, and they cover the others. Now, in 2013, Parliament passed legislation, the Enterprise and Regulatory Reform Act, which actually specifically set out that claimants could not rely on a breach of these regulations as evidence of breach of duty. Before that, claimants would say, well, there's the regulation, you haven't complied with it, that's breach of duty. But this legislation said they couldn't do that. So in other words, they would have to go back to the common law and prove the case in negligence. And from a defendant's perspective, that was quite a positive thing. But what has happened in reality is that the courts have adopted the provisions in these regulations as setting the standard of care in negligence, and that is why you will still see these regulations pleaded in cases or in letters of claim, and that is why you will need to have a working knowledge of them. And as they set out your obligations anyway, they're a useful starting point when you're considering breach of duty. Now, each of these regulations is detailed and contain a lot of information, so we can't go through that today, but there are some common features. They all require employees to carry out a suitable risk assessment to identify risks to health and safety for employees, for example, from manual handling or the use of work equipment. And then employers are required to implement measures to reduce those risks to the lowest level reasonably practicable. I've just put this slide in just to show there are other statutory provisions which crop up probably less often, other than the Occupiers Liability Act, which I am going to mention separately in a moment. So the Health and Safety at Work Act is an important piece of health and safety legislation in the UK. It imposes obligations on employers to provide a safe place of work, safe equipment, to ensure staff are trained to carry out risk assessments again, to provide proper facilities such as toilets and drinking water, which should be maintained, and to appoint a competent person to oversee health and safety. So if you compare that with the Clyde Cole case, you can see they're very similar, the sorts of things that will be imposed on employers as duties. Okay, so some of the other slides there, we will be dealing with those in subsequent legislation. We'll be dealing with that in subsequent seminars. I do want to mention the Occupiers Liability Act 1957, 1984, because they crop up regularly in the claims we deal with. Now, they apply to both employers and public liability scenarios. So the 1957 Act imposes a duty on occupiers of a site or premises, and I'll read this out. To take such care as in all the circumstances of the case is reasonable to see that the visitor will be reasonably safe in using the premises for the purposes for which he is invited or permitted by the occupier to be there. So it's to take reasonable care to make sure the visitor is reasonably safe. Now that's section 2 of the Act, and it's known as the common duty of care. The Act also provides that an occupier must be prepared for children to be less careful than adults. And also an occupier can expect that a contractor who's on the premises to carry out their calling will appreciate the dangers relating to what they do. And so the occupier, the duty of the occupier in relation to those aspects is reduced. Now, the Act also provides a statutory defence at section 24B. And this relates to situations where damage is caused to a visitor by a danger which is due to the faulty execution, maintenance, construction, or repair carried out by an independent contractor, provided the occupier was acted reasonably in selecting the contractor and trusting him to do the work, and is satisfied that the work had been properly done, then there may be scope for avoiding liability on the basis of that statutory defence. Now, the 1957 Act didn't provide protection for trespassers. The 1984 Act clarifies that whilst occupiers do have a duty to ensure the premises are reasonably safe for, reasonably safe for visitors, the 1987 Act clarifies that this will also apply for trespassers. There are certain circumstances which need to arise. So the occupier needs to be aware of the danger or has reasonable grounds for believing it exists. The occupier knows or has reasonable grounds to believe that the other person is in the vicinity of the danger or could be expected to be there, and that the risk is one against which the occupier might reasonably be expected to offer some protection. So we've got the Occupiers Liability Act, which applies to both what we call lawful visitors and also trespassers. Okay, so we've looked at common law, we've looked at some of the statutory provisions, Now, the regulations, the sick pack regulations, introduce more detail, really, more obligations. And as I said earlier, they are very detailed documents. What I wanted to do is just exemplify by reference to two types of claims, how they operate and how they impose different duties on employers, more specific than the wider duty of care we've looked at previously. So in manual handling claims, the manual handling operations regulations set out a hierarchy of things which employers need to consider. And I think it's important that there should be some evidence to show you've at least considered these things. I mean, the risk assessment you've got to do. But so the first thing to consider in the hierarchy is whether you can avoid the need for employees to undertake any manual handling at all. So it should be eliminated if possible. Now, in large organisations like the NHS, there are thousands of manual handling operations going on every day, and it's not going to be possible to avoid them all. So if you can't avoid the operations, you've then got to undertake a suitable and sufficient risk assessment, taking account of various factors in the regulations. So the idea there is to identify the risks which arise. And then the next stage in the hierarchy is to take appropriate steps to reduce the risk of injury during those operations to the lowest level reasonably practicable. Now, that might be by the provision of mechanization, things like slings and hoists, provision of guards on machinery, that type of thing. And then there's an additional provision which says you've got to provide employees with information about the load itself, the weight, and the distribution of the weight. So that's just an example of how these regulations impose more detailed obligations on the employer. Similarly with trips and slips, so we have negligence, common law. Then we have more specifically the Occupiers Liability Acts, 1957 and 84, which we've looked at. And then we have in the six pack, the Workplace Health, Safety and Welfare Regulations, 1992. Okay, now I won't go through everything that's on that slide, but you can see that the duties set out is in relation to obstructions, construction, the state of traffic routes, and tripping and slipping hazards. And they are things that we come across commonly with employers and public liability claims. Okay, so moving on to how do we defend these claims? And we're talking about what documents and information do we need at the outset. I've mentioned the word evidence on that slide, and I think it's worth emphasising that point. Often we encounter claims in which there is doubt about the claimant's veracity. Sometimes there may be multiple claimants. It comes across that staff at the trust don't like the claimant. And things like that can make a trust less inclined to agree a compromise or settle a claim, or it may simply be the value of the claim is an obstacle. And whilst we will always discuss those issues with you, we will always take those into account. What I want to emphasise is if you want to defend a claim, you need to have appropriate evidence. That is what the court will have. That is what is in front of the judge, and that is what he will base his judgment on. So we can have various suspicions and concerns about a claim, but we've got to have the evidence if we want to defend it. Okay, so some of the other things I've mentioned on that slide, training, this is going to be crucial in a lot of cases, and the training needs to be up to date and documented. If you're going to defend an allegation that the claimant wasn't properly trained, it's really helpful to get a statement or comments from the trainer and the course materials they used when the training was implemented. And they should be the contemporaneous materials and not the most recent. And training is vital in manual handling cases, and also particularly in cases for mental health trusts where there's been an assault by a patient on a member of staff. So it's necessary to demonstrate that the staff involved were up to date with their personal safety training, as were the colleagues who were assisting them at the time. And that's often a very crucial piece of evidence. Now, witness statements and staff comments, the point I wanted to make here, and I'm talking about informal comments now at an early stage, the point I wanted to make here is that the sooner they are obtained, the better, when memories are fresh and the evidence is more cogent. I also think you need to consider, in particular, the relationship between the injured person and the potential witness. Sometimes we find out they're friends, and sometimes we find out that it's well known they don't like each other and they've had run-ins in the past. And so that can affect the credibility of the evidence. And then we need to consider, did the witness actually see the incident or just the aftermath? Were they told by somebody else what had happened? Because again, that will affect the credibility and the weight which is applied to that evidence. Risk assessments, I have mentioned these several times previously because they're often a requirement anyway due to the regulations, but they are very important in the event a claim is made, because you will see pleaded all the time the defendant failed to carry out a proper and sufficient risk assessment. In manual handling claims, they are a crucial part of the evidence because of the hierarchy we've just looked at. And again, in assault claims, this relates more to an assessment of the risks arising from patients and from the care plans to show that we've addressed those risks. But again, having that documented and up to date is very important, and it's a very important part of the evidence if you want to defend these claims. Another thing is, if you update a risk assessment, you should always keep the previous one, because when it comes to dealing with a claim, it's the contemporaneous document that we will need. That's much easier nowadays that we file things electronically. So, but it's important that you keep the old copies. Okay, so PPE, it's hopefully self-explanatory. It comes in many forms, and what is appropriate will depend and vary on the work being undertaken. But the PPE must be suitable for the work which is being done. I wanted to mention that about enforcement, because we've slipped up on lots of claims where the trust says we've got a policy for PPE. We've provided the PPE to employees, but then it turns out that the use of the PPE wasn't enforced. And I'll give you an example. I went to a trust to investigate a deafness claim in a laundry. And of course, the trust had a policy which said, yeah, we provide ear defenders. It had evidence of people had signed to say they'd had these ear defenders. And then when I walked into the laundry with the manager, people had them round the neck and weren't using them. And that's when the manager's there. So as well as providing the PPE, you've got to make sure you enforce its use. Up-to-date policies and procedures, safe systems of work for things like cleaning and inspection documents in equipment claims, maintenance documents in equipment claims are very important. And allied to that is good record keeping, because those people who carry out the inspection on, let's say, machinery will need to document when they did it, why they did it, what they found, and if there were any faults, how they were rectified and when they were rectified. So good record keeping as well as having the systems in place. Now, I've mentioned contractual documents there because we do come across claims where there's a dispute between the trust and the contractor engaged by the trust to undertake work or provide some service as to who's at fault for causing the accident or event. And in such cases, having a signed copy of the contemporaneous contract can be really helpful, because they very often set out the responsibilities of both parties and can actually contain specific indemnities which can be implemented in the event that an incident occurs. And the last thing I wanted to mention, and this is a bit abstract at this point, is DATIX forms. Now, DATIX forms are almost always available when by the time we pick up a claim. The point I wanted to make is to consider how comments are recorded in the form or on the system. And I'm not saying you need to doctor the comments the forms have got to be accurate. The forms have got to contain the right factual information. But sometimes I get the impression people just, and it's not a criticism, people just want to, in lessons learned, for example, or I need to put something in there, so I'll put this. And that's fine, because they are used for lesson learning. But I'll give you an example here. It's just the way things are phrased. I was recently asked to look at a slipping case where the trust had employed a contractor, a competent contractor. The contractor had a great system for identifying when it would be necessary to come out and grit the site. On the occasion that the incident occurred, the contractor's system worked perfectly well. They attended the site and they gritted as they had to do. So we had really good evidence, which could form the basis of a defence. But on the lessons learning section of the form, somebody had put estates need to improve to make sure this doesn't happen again. Now, that's not a criticism of the person who recorded that, but I got the impression it was a throwaway comment. But if that goes before a judge and he picks up on it, which he likely will, he's going to say, well, hang on, why are we saying that these states need to improve? And then you're on the back foot again then. So it's just something to bear in mind. I thought it was worth raising because we're all here. Sometimes just think about the way things are phrased in the contemporaneous documents. I think that's all I wanted to say. So thank you for listening to me, and I'll pass you over to Tom.
Good afternoon, everyone. As Ian says, I'm Tom Lomas, one of the senior associates in the health litigation team over in Manchester. Now, for the next part of the talk, I'll discuss how all this fits in together once a claim has been brought. So to put this into a bigger picture, there are two parts to the process, the pre-action protocol, and then if the claim is unable to be resolved, the matter moves to proceedings. In terms of the pre-action protocol for ELPL cases, this is the time when investigations are conducted and an initial liability decision is made. The aim of the protocol is for the defendant to pay damages and costs in appropriate cases without the need for the claimant to issue formal court proceedings. It provides timescales for a liability decision to increase the speed of the claims which are being dealt with and efficiencies, and to ensure that damages are paid within a reasonable time frame. And this is all meant to limit time and costs. There is, however, a bit of an apology here because as a result of that, the next section of the talk has an awful lot of timescales and processes. It's quite procedural. But the purpose of the protocol, like I say, is to really limit. So the pre-action protocol, well, when does that apply? For ELPL cases, it applies when an incident occurs after 13th of July 2013, which frankly is most cases. It has to involve damages for personal injury more than £1,500 and less than £25,000. It has to involve damages for personal injury as well. There are a number of exceptions to the portal which are set out on the slide. I won't go through them here, but those are the main exceptions. In addition, the claim should not be processed through the portal where the claimant is bankrupt, where the defendant is insolvent and there is no insurer, for disease claims where there's more than one employer defendant, for incidents that occur outside of England and Wales. And so those are cases where the traditional route would apply. It should be noted here that there's quite a strict interpretation of the meaning of an ELPL claim for which the protocol applies. In a case called Bateman and Devon, the claimant in that case was riding a motorcycle and fell off along the public highway, for which the defendant was responsible. but it was held on a strict interpretation of the rules that the case did not fall within the RTA or the ELPL protocol, and accordingly the fixed costs which are attracted within the pre-action protocol do not apply. I should, however, say here that where the damages are estimated to be over £25,000, then claimants would follow the traditional letter of claim / letter of response process. So the ELPL protocol is a three-stage process. I will go through these in depth, but the overview is stage one, where the claimant issues a CNF, and the defendant then has the choice of admitting or denying liability. Some claims fall out of the process at this stage, but more on that in a bit. If the claimant then proceeds to stage two, this is the point where the parties can get their heads together and try and negotiate settlement. But if that can't occur, stage three is the court process. So as you can see here with the three stages, it is quite procedural and formulaic, but also it gives the opportunity for, as you will see, we will discuss the opportunities afforded to a defendant to try and resolve cases which enable parties to keep costs down. So firstly, turning to stage one, this is where the claimant sends the claims notification form to the defendant's insurer. Here in this case, NHS Resolution, the insurer then must acknowledge the CNF within a day after receipt. However, the claimant would not be able to take the claim out of the portal if this wasn't done in time. Also, if the CNF is sent by post as opposed to online, an acknowledgement also must be sent. The insurer sends the claimant an electronic acknowledgement, and the claimant is required to submit the CNF as soon as possible if done initially offline. The CNF form needs to contain all the relevant information for the claim, including the injuries alleged to have been suffered by the claimant. At this stage, the then onus is on the defendant to investigate the claim. So all those things which John discussed in terms of investigating claims, witness statements, statics, riddle, all those things would be important at this stage. The defendant also, as it says there, needs to register the matter with the Compensation Recovery Unit. And as I said earlier on, the timescales are very tight and they are important to portal claims. So for an EL claim, the defendant has 30 days to respond. In a public liability, it's 40 days. And this is working days, not weekdays. So defendants really don't have long to respond to claims. And I think it's important here to note that as soon as the trust or the defendant gets wind of a claim earlier on, maybe it was an incident, that these investigations which we discussed earlier get put into place, because as I say, once that CNF lands, the trust does not have long to make a decision as to whether to admit or deny. So in terms of the response, once the investigations have been taken place, if the defendant decides to respond with an admission, then the claim remains within the portal process. An admission within this context means that a defendant agrees that it breached its duty owed to the claimant, that it caused the claimant some loss, and limitation has not expired. So once the admission has been lodged, the claim moves on to stage two, which we'll discuss. The defendant has 10 days to pay stage one costs, which are £300 plus VAT. If the matter is an EL matter, an employer's liability matter, then the defendant has 20 days from the date of the admission to provide the earnings details of the claimant. So that would be usually earnings documents, usually 3 months prior to the incident, and for the relevant absence period from any time off work. If, on the other hand, following the investigation, the defendant decides to deny liability, then reasons must be given for that denial as to why we do not agree that we are liable to pay the claimant damages. And at this point, if there's denial, then the claim would drop outside of the portal. So, in cases where the case exits the portal, it's an admission of liability at that stage is not the only reason when a case might drop out in the case of denial. Also, if contributory negligence is alleged on the part of the claimant, or it could well be that the CNF was not completed within the relevant timeframes. For instance, if the investigations have been taken too long. So here, like I say, it's important that the timescales are adhered to and that the house is put in order as soon as possible so the case doesn't drop out of the portal unnecessarily. Obviously, as with a lot of things, if the case does drop out of the portal, then increased costs will apply, which obviously we want to avoid if at all possible. It should be said here that if the CNF, if the case does fall out of the portal, then the CNF stands as a letter of claim, and then the defendant has 3 months to respond in the usual way. So turning to stage 2 then, if it stayed within the portal. So this is the case, this is the stage where the parties really try and bang their heads together and reach settlement if at all possible. The claimant at this stage obtains the medical report. Under paragraph 7.2 of the protocol, it states that it is expected that most claimants will obtain a medical report from an expert, but maybe one or more in the relevant discipline. And also, obtained to that will be medical records, any relevant photographs of any injuries, and anything like that which assists the claimant. Once the evidence has been compiled, the first procedural step at the beginning of stage 2 is whether there is a request for an interim payment and whether this should be made. If one is requested, the portal has a relevant button on it which can be pressed, and an interim settlement pack can be sent in. If the interim payment is up to £1,000, then this is considered to be general damages and payment must be made within 10 days. If, on the other hand, the interim payment is more than £1,000, then the claimant would have to provide evidence of financial losses, for instance, receipts and that kind of thing. And if the payment is made, then the defendant is required to deduct CRU benefits if applicable. The payment must be made within 15 days of receipt of the interim payment pack. If the claim is valued more than £10,000, then the claimant can return to this stage and request further interim payments, but no interim payments can be made in child claims, and if one is in fact required, then the claim exits the portal and the usual court process, which we'll discuss in a bit, will apply. So once the claimant has obtained their evidence and medical reports, a stage 2 settlement pack should be completed. This must be sent within 15 days of the claimant approving the final medical report and agreeing to rely on the prognosis contained within that report. And then once that settlement pack is sent to the defendant, they in turn have 15 days to consider the settlement pack and any evidence. The claimant's pack will contain an offer so that the defendant has got the option to simply accept it or make a counter offer. The counter offer at this point needs to include an appropriate amount which the defendant considers for each head of loss. And the defendants also need to give an explanation as to why a certain head of loss is being reduced. So the different heads of loss might be PSLA, for instance, or care and assistance, or other losses. The parties then have 20 days to negotiate. And if settlement is reached in that stage, then the claimant has 10 days to pay damages and fixed costs, as well as disbursements. For claims below £10,000, it's £600 plus VAT, and over 10,000, it's £1,300 plus VAT. However, if we fail to reach settlement within the stage 2 process, then the matter moves to stage 3. And this is where a court proceedings pack is created. And within that, there's 2 parts. Part A contains the claimant's losses and the amount the claimant wishes the court to award, and the figure that the defendant wants the court to award, along with the comments of both sides. It's important here to note that anything that hasn't been raised at stage 2 can be included within stage 3. There was a case called London Borough and Burris, where the Court of Appeal held that the defendant can't object to a particular head of loss at stage 3, except within the grounds which were raised at stage 2. So the message here is that it's important that the defendant fully explains any challenges within the stage 2 settlement pack, otherwise the opportunity has simply been lost. Part B contains the final offer of both the defendant and claimant, and the pack is then completed by the claimant and sent to the defendant for potential agreement. They've then got 5 days to check and confirm. The defendant then has 15 days to pay the stage 2 offer, any unpaid stage 1 fixed costs, stage 2 fixed costs, and any agreed disbursements. So then stage 3 can finally commence. The claimant can print out the court settlement pack and sends this to court with the claim form and the appropriate fee. Part B of the court pack should be placed in a sealed envelope, which can't be accessed by the judge until they've assessed damages. Here there's a choice as to whether an oral hearing is required or whether the court can deal with the matter on the papers. An oral assessment of damages hearing will be given if either party has requested it, or if the court of its own volition considers it necessary. And the court will give at least 21 days notice of any hearing date. It's important to note here that if an oral hearing is granted, then submissions are only allowed and not oral evidence. So it's important that everything is placed before the court in the early course, and hopefully not there's an intention to turn up on the day and argue over anything, because, like I say, there's case law that suggests that everything needs to be done at the early stage if it's going to be allowed in. Okay, so that's the first bit. That's the MOJ portal for ELPL claims. And as we've discussed, there's an awful lot of backwards and forwards and opportunities for the parties to get their heads together. And the reason for that is because formal court proceedings are seen as a last resort. If the claim exits the portal for any reason, then we end up at this point. However, we need to be alive to claimants issuing formal court proceedings before they should do, either before we've had a chance to respond within the letter of response stage, or if we've offered, say, a limitation extension which has not been taken up by the claimant. We might then have arguments in terms of costs if the claimant has run off and issued proceedings, in our view, prematurely. So It's helpful here, I think, to set out the court process. And again, this is aimed perhaps with people who don't have as much experience in this field, because it's helpful to show, I think, the process and the timescales involved, and to emphasise that the investigations which John talked about earlier on need to be taking place in the early course. So that's the process there. So first of all, the claim form. The claimant issues the claim form. What's that? Well, the claim form is the document which is used to start proceedings and contains all the information relevant to the proceedings, including the court reference number, the claimant's identity, what's being claimed, how much the claimant seeks the court to award, any claim for interest, and importantly, it should contain the particulars of claim, which is the document which sets out the facts surrounding the claim. Often, the particulars of claim, which we'll discuss in a second, are contained within a separate document, but in case they're not, it should be within the claim form itself. Claimants need to comply with the practice direction and the CPR Part 16 if you wish to have a look at that. I won't go through it now due to time constraints, but I think one of the key issues we need to look at here is limitation. Has the claimant brought the claim within the 3 years allowed? Generally speaking, if there's claims involving children or protected parties, then this will obviously not apply, but it's important to check. Timescales and deadlines are very important here. When a trust receives or an insurer receives a claim form and particulars of claim, then it's very important that it's reported as soon as possible to the insurer and or panel firm so that the necessary action can be taken. So in terms of the claim form itself, that needs to be issued within 3 years of the incident or date of knowledge of the incident, and then it needs to be served within 4 months of issue. The particulars of claim, if they're contained within a separate document, they need to be attached and follow to the claim form when served, and if they're served separately, they need to be served within 14 days of the claim form. Here, the particulars of claim should, again, the requirements and formalities of CPR 16, which I won't go through, though it should set out a concise summary of the facts which the claimant considers the defendant to have, the reasons it's breached its duty, setting out its claim on causation and any injuries. And again, I've put there again, timescales and service deadlines are very important. So again, if you are faced with a document with the particulars of claim and claim form, please refer them as soon as possible to the insurer and or us. Once the documents have been served, then it's put back on the defendant. Again, a strict timeline is in place for filing that acknowledgement of service, which is 14 days, and then 14 days thereafter for filing a defence. And it's important here to note that this is a very strict deadline. If these deadlines are missed, the claimant may try and enter judgment. And whilst ever we can apply to set this aside, it's by no means guaranteed. So it's always best to comply with court deadlines if at all possible. So in terms of the defence, what should this contain? Well, a bit like the MOJ portal, do we admit what the claimant is alleging or do we deny it? Need to be careful with non-admissions or bare denials because we need to give reasons for a denial. And again, the defence is verified by a statement of truth. So all those investigations which took place in the early days of the claim, or indeed the incident if beforehand, we need to familiarise ourselves at an early stage with all of the investigations undertaken, because the defence which you will be asked to sign is verified by a statement of truth, which means that it's a declaration that you agree to the facts contained within that. Just for completeness, although it may not necessarily apply to you day to day, the court then looks at these documents and either issues draft directions if it's a fast track matter, or issues a notice of hearing for a costs and case management hearing, or CCMC, in multi-track cases, which are the higher value cases. The role of the judge at this stage is to then manage the case, actively case manage the matter with directions. And again, this one's a matter for us really, but once a directions order's given, they need to be diarised, and the directions are need to be complied with timely. And I think, again, this is important to emphasise here that we can get extensions, but no means guaranteed. So again, the investigations which need to take place proactively at the early stage, so we don't end up in this position if it's avoidable. And again, if the house is in order in the early course, then the list of documents is a document which reflects all the stuff which we are obliged to disclose to the side. So that might be datics, it might be investigations, it might be comments obtained within the purposes of the incident, not the litigation, because those wouldn't be disclosed. But again, here, I think the message is we need to be careful how sometimes we refer to perhaps the claimant or the incident, because unless it's in contemplation of litigation, it's going to end up being sent to the other side, which may have some embarrassment depending on how we've referred to the claimant, perhaps in some incidents. So it's just keeping in mind really that when we do investigate claims, ELPL claims early on, need to ask ourselves, is this going to end up with the other side at some point, and potentially before the judge? Similarly with lay witness evidence as well, this is very important at the court stage. So I think it's important to get the engagement of trust witnesses at an early stage and really pull them through the process and obtain witness evidence early on. People can leave trusts, so it's important that people are engaged and also supported, I think, as well, because giving evidence, whilst ever the topic, an entirely separate topic in its own right, it is important that the lay witnesses are supported as best as possible. I won't really go into expert evidence too much, save to say that on low-value cases, we don't always obtain expert evidence challenging the claimant's own evidence. But in case we do on higher-value cases, or particularly novel claims, the next stage in the court proceedings is to exchange that evidence with the other side, and then the experts then get together and produce a joint statement in an attempt to narrow the issues before trial. Again, the whole process here is to sort of streamline and bring the case through without having to avoid, trying to avoid the final trial, if at all possible. So there's plenty of opportunities where to take stock throughout this whole process and to try and negotiate settlement. Then updated schedules of loss and counter schedules are served, but I don't anticipate going through those in this session too much. It's just as a FYI. So if after all of that we can't settle the claim, we proceed to trial. It can be quite stressful giving evidence, so I'm told. I've never given evidence, but it's very important at this stage that we support any clinicians or witnesses, maybe from estates, maybe claimants' line managers, etc. And we obviously are always on hand to give as much support as is necessary, given that giving evidence is quite stressful. And then the final thing in terms of giving evidence really on the day, again, it's obviously everyone will turn up at the county court, and often the claimant will go first, give evidence, and then it will be the turn of our witnesses to give evidence, and then the court will make a judgment. It's important here that the witness evidence and the witnesses generally are, everything has been explored with them before witness evidence is exchanged. The reason for that is because the witness evidence will stand in what's known as evidence in chief, which means that there are not any particular opportunities to expand on the witness evidence once we get to court. So again, the message here is that cases need to be proactively managed as early as possible, so we can take a view as to whether cases do proceed to trial. And I think that's everything which I wanted to discuss in that session. But I'll hand over to Ian Gardner now. Thank you very much.
Thanks, Tom and John. I did warn that there was a lot of information to go through, and I probably wasn't lying. What we wanted to do was give you as full a picture, as full as an introduction as we could do. I mentioned there's the Q&A icon for people to raise any briefish questions, I guess, looking at the time at this stage. But again, as I said earlier, if people did want to follow anything up in more detail afterwards, then please do so.